singer from Bombay who was acting with Shahrukh Khan. So she was talking with me, but somebody came, he's very lefty. They immediately called me uncle.
So there is many long years and happy years to you, and also young years to you. So, so today we are having this conference on this subject, on this dematerialization of securities in the digital era. Now, to my mind, I mean, very honestly, I had a lot of questions were put to me, but to my mind, this dematerialization is a very good step. According to me, it's a very good step, and it's a step in the right direction. Now, recently, a question was raised as to because I would like to go into the nitty-gritties, you to go into the nitty-gritties, but a question was raised that the private companies have come within the fold of dematerialization and they have to dematerialize it. But as far as my understanding goes, that the small companies have been exempted from private companies. And the definition of the small company is the capital of 4 crores and less, and the turnover of less than 40 crores. According to me, 99% of the private companies, if I'm not wrong, or maybe 95%, let me put it this way, the 95% of the private companies will come under this category.
Yes.
So therefore,
they will be exempted.
So therefore, there is nothing much to worry. So Ranaji, I was taking your point that large companies, only large private limited companies will come under this, because as far as other private companies are concerned, they will not come within, because it is 4 crores and 40 crores. That was my feeling. I may be absolutely wrong. We will be, yeah. 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 So the other thing which I wanted to tell you that being a director of so many companies, I have been attending these meetings, and most of the shareholders, according to me, are not only literate shareholders, but all the shareholders are very digital friendly. You see today what is happening, that annual general meeting are held digitally. So therefore, they are participating. The votings are done digitally. So they are voting digitally, whether you are a small shareholder or you are a big shareholder. So therefore, as far as voting part is concerned, these small shareholder, big shareholders, they are all voting. It's not that they are not voting. So they are very digitally. And then the question remains that if you, and I was, they say that there are 26,000 companies or 28,000 companies in India. But as far as the listed companies are concerned in the National Stock Exchange, it is around 2,000 companies. It is exact figure is 2,113. It may have gone up to 100 or 200 more.
Near
about that only. And as far as the trading in the shares are concerned of the listed companies, where the people really trade in the shares, it's not more than 200 to 300 companies. So that is and as far as the number of shareholders are concerned, to the best of my recollection, if I'm not wrong, it is last figure was 80 million investors, that is about 8 crores in a population of 140 crores. And out of 8 crores, how many would be the corporate investors? I mean, shareholders. Apart from individual shareholders, there are corporate shareholders. So how many would be individual shareholders?
45%.
45%, he says, it will be individual shareholders. So therefore, we would have round about 35 million shareholders, 3.5 crores as individual shareholders. Rest will be corporate shareholders. For corporate shareholders to comply with demat will not be. So, to my personal feeling is that the step is in the right direction. Demat holding is in the right direction. Demat holding, as far as the private limited companies are concerned, it's also in the right direction, because it is only the large private limited companies who will come. But I would like our chief speaker today and the chief guest to tell us the nitty-gritty about our dematerialization. Thank you very much. The floor is yours.
Thank you, sir.
Yeah.
Well, good afternoon, everyone. And before I start, thanks to Bharat Chamber of Commerce for this invitation. Of course, this is my second time. A special thanks to D.N. Agarwalji for this, extending always a warm welcome to this Bharat Chamber of Commerce. It's a really pleasant evening to meeting you all because we're starting in the afternoon, but by the time we'll wound up, it will be evening. The topic also is very like I will say the delicate issue where we are discussing, and as sir has already briefed so nicely, and thank you sir for extending your heartiest welcome to me. And almost you have covered like what exactly we are talking about. When we are talking about this private company, what happens is that first, when the ministry came in this dematerialization picture for the public company, it was well accepted because people said, okay, the public company, it is not about private company. The moment in this October they have extended to private company, there is a lot of budge. People are talking that, okay, is not a welcome move. It will be onerous on the private company. It will become a burdensome or it's another compliance. Well, I will say is mixed feeling is there because if you look at the one way, it's a welcome move because the reason being there are so many of cases which happens due to physical share certificates only. Because what we heard about in a private company, if you go to the private company, there will be issue relating to transfer of securities. The people are not talking to each other. Now there is operation mismanagement is going on. The one person is blocking the transfer of the share certificates of the another one. So this operation mismanagement issues are arising. Second issue, that say, for example, if this issue is going on, the litigation is going on between two brothers, two friends, whatsoever, then what happens ultimately down the line, 10 years or 15 years, a person is no longer there. Then the legal heirs faces the challenges, or you can say the family members, because when they approach the company that there were some certificates, they get the normal answer that, okay, there was no certificate. Why? Because the fraudulent transfer has already took place. Person is no longer there, says certificates have been transferred, they have shown the transfer, everything, books is clear. So now again you will fight in the courts and you will go to the tribunal, etc. So ministry perhaps want to address these issues. Now this rule itself, which has been introduced by the ministry 9B, straight away the first line itself is that every private company other than a small company. So that means their main motive remains the same, the ease of business. They are not going to cover the small companies. And small companies no longer, perhaps, like if you talk to me, I will say small company is not a small company any longer. The threshold they have given is a very wider enough. The capital of 4 crore and turnover of 40 crore is good enough. Because if you say that, okay, beyond this also, if the company becomes triggers the applicability and you will not be able to comply with these issues, then I will say like the company is saying in exaggerated mode against the ministry. Because if you are having crossing that threshold, it doesn't become a challenge for you to comply with the requirements. But at the same time, why I started with the mixed feeling is that the ministry needs to ensure that the adequate infrastructure is there in terms of depositories. Because when we talk about the private companies, you know that even I do agree that, okay, almost 90 to 95% of slab are within these small companies. But in India, we have the numbers of private companies which ranges at present data 16 lakh. So there are still many companies which comes under the gambit of compliance for this purpose. Now, if you approach the DP, what is becoming a challenge is first that not only the company is obliged to get the shares dematerialized, the company is under the obligation to facilitate, and the facilitate that rule 9B gives the responsibility on the company to comply with three primary criteria. The one is that you facilitate. How you will facilitate? Second, by securing ISN. That means International Security Identification Number, which generally we get for dematerialization. The third step is that informing the shareholders. Now there comes the main challenge, which the private company has to comply with. Because you know that at times what happens, we have got the dematerialization shares. We are saying that we are extending the facilitation. But then the third leg of compliance, which says you should inform your shareholder as well, becomes a challenge. Because on those companies, many private companies, you will see there are certain issues going around. Now, with this trigger of compliance, no one will take that chance to inform the shareholders. There is a proper saying that oh, so bal ko kaun jaga hai? That okay, I'm sending you the notice that get your shares dematerialized. The immediately shareholders will come and then will say, "Ki what are you doing? Who has allowed you and why I don't want to get my shares dematerialized, or I am blocking you from dematerializing the shares of the company." So issues will be there in those kind of a company, but there are ways because it says inform the shareholders. There is no more prescribed. The best way that a private company which gets under the applicability of the threshold is to ensure that whenever their EGM or AGM happens, do inform the shareholders by way of a notice, like because you will be disseminating the AGM notice, EGM notice. The best way is to cover by way of a notes to the notice itself, because that is a one thing that I've come across major of the seminars which I've took or I've taken all the like a topic called dematerialization for the private company. Everyone was worried that how we will inform the shareholders. The moment we are going to inform, it will become a challenge. So there is a way out. You inform by way of a note, sending the notice. Like when your notice is going around, you are informing well that giving the notes to the notice. After complying with these three, next issue comes is that there is a one rule which is onerous, which I think for the private company they have to look into. The one is that remaining compliant as far as the timely payment of fees to the custodians is concerned. Because they are saying that, say, for example, if you are further issuing shares or like you are going for the private placement, because private companies is having only route of private placement, they can't go for the public. So if they are planning for a private placement or they are planning for a bonus, rights, so whatsoever, they have to ensure that there is a timely payment of the custodian fee. That this rule, particularly for the private company, has to be looked into, because no doubt it is well safeguarded by another provision where the rule sub rule 6 says that unless you have made the fee, entire payment of fee, you can't issue the further shares. But then again, reading the rule 5 only in isolation, it is a contravention of the rules. And the moment it is a contravention of the rules, again you go to the 454, because you never know adjudication order which will come to the private companies. Because recently, in this January month only, we have got two adjudication order. And interestingly, the ministry is now going into the nitty gritty. The ministry is looking into the filings, looking into the papers very thoroughly. One of the case is all about electronic company, no doubt, where it was having the foreign investment. So there was a more so kind of I will say more than order. It was a kind of an investigation. But the other company, they made just simple blunder mistake that they were filing the shareholding details, etc., as a part of annual return. What they have missed is that only giving the declaration of beneficial owner. Because you know that in a private company, in a public company, we all know there is a minimum requirement of 2 or 7 shareholders. So now ministry is looking into the SBO in so detail that 2 shareholders were there. They immediately traced out whether the MGT 4 or 5 there is in the record or not. And it was not there in the record. So the company got immediately a notice from the department. So the kind of a vigilance they have, like you can say they are throwing or they are putting on the private companies, is becoming a challenge as far as this rule 5 is concerned, where they are saying that you need to be remain compliant with the timely payment of fees. And second, which I think that, okay, well, these are the compliances that we need to do, the timely compliance and the custodian fees and facilitating the ISN, everything is, well, we all can do. The one more issue that will become, or that I think ministry is also considering, because in our last discussion, even with the ministry, they said that they are looking into it. What they missed out, in a public company, you will find there is an exemption for the wholly owned subsidiary company they are providing. Means, let's say, for example, A Limited and B Limited is a wholly owned subsidiary of a public company. So that is getting straight away exempted, because perhaps the intent is to take the dematerialization where the shareholder base is there, not that where only one shareholder is there. Similar exemption they have missed out in a private company, because in private company, the only exemption when we are talking about, it's all about in the sub rule 1 for the small companies. And then you can say the blanket exemption is as usual for the government company. But then they have missed out to state that it should not be applicable for wholly owned private company. Because what happens is that in many cases you will find private company generally in a groups are formed. So there will be cases where 1 or 2 private companies are formed. And here the problem will come, because here the small companies exemption will not be there. Because small company means a company in isolation. If it is a subsidiary, if it is associate, it's no longer a small company. So even whatever the size it is, even say, for example, a capital of 1 lakh is there, it will not be a small company. There it will become challenge if we do not get this exemption from the ministry, because this is very crucial. Many of the companies you will find down the line are like in a shape where they are forming two or three, you can say step down subsidiary, 2, 3 associates. So all these company will be out of bracket from the small company. And then these company will attract the applicability of your dematerialization of shares. So unless or until ministry clarifies, because though we have a time, but then before that time, well, the ministry needs to like make sure that the people in general should be aware that these steps are not required to be taken by them, because otherwise time also is very constant now. All the way rule has come in the October stating that the first checkpoint of compliance is that check the balance sheet as on 31st March 2023. So that means we have to check the balance sheet of 31st March 2023 to ensure whether it's a compliance or whether it's a small company or not. If it is not, then the trigger point is within next 18 months. So by 30th September, which is like we already in the month of January 2024, so we hardly have 8 months or 8.5 months to comply with this requirement. Because there is another requirement, because ministry don't want to miss out any chance. They are keeping you can say a watch on the every compliances nowadays. Despite doing your necessary steps, taking the facilitation, they have the another check of round by way of a filing of form, which is pass 6. So pass 6 will be filed, the professionals will be allowed, it's a chartered accountant in practice or the company secretaries in practice. They are allowed to certify this form, which has to be filed effectively your September 2024. Once it is ended, they have to file the form. Now, when they while filing the form, you can't immediately run to the NSDL and CDSL to get the ISIN. Probably at that point of time, we don't know if the ministry in no mode they will give the extension, because 18 months is a very wider enough period they have already given. So if you look at this scenario, we have to take all the steps, all the, you can say you have to fasten your belt as of now. By 30th September, this should be there clear in the books. And then basis which you will be filing the pass 6, because otherwise, if you don't have the ISN, there will be issues, technical issues with the filing of forms as well. And ministry, as far as this technical issues have no, like there is no end to technical issues. So at that point of time, you can't come and say that, okay, we are in the process of obtaining that. Even there is a delay of a cases, they have imposed the penalty. We have come across a cases of Sri Vidhi services. The company is just a mere 2 days default. Like what they have done, basically, they have issued the shares and then they realize that, okay, this was required to be dematerialized. Immediately after issuing these shares, noticing the provision, they have immediately recalled the notice and issued the further notice that, okay, we are getting the shares dematerialized and this should be read in conjunction with that earlier notice. But somehow AO, the adjudication officer, was having a tough stand on that also. And they imposed a penalty roughly around 32 lakhs on the company for a, like you can say, public size company. Though that was a public size company, in private company, they will give due regard, because they also need to consider various factors, the kind of a reputation of default, the size of a company. These all are the factors which AO considers. But time will let us know, because the kind of cases we are coming across, it's not going to be an easier one. So there are, like, to my mind, I will say is a very welcome in because on the first side, there will be a lot of issues which will be resolved as we discuss. The second, yes, there are certain kind of onerous provision like payment compliance, payment of fees well in time, remaining compliant with that. That is the first issue. The second, giving the exemption, extending the exemption to wholly owned subsidiary. That perhaps I think they will extend, but then again they need a representation. This I also request this chamber as well to make presentation, because that is very much essential to give the wider bracket to all the private companies. Now, having said those provisions, there are 2, 3 things also in mind. People do consider that what happens, say, for example, at times a question arises that in cases where we enter into an agreement between the two companies with a restriction on transfer clause, we particularly say that, yes, obviously, without the consent of the other party, you can't enter or can't execute the share transfer. So what will happen in those scenarios? How we will facilitate dematerialization in such scenario? So there is a concept like NSDL, CDSL already have in system, and that is well accepted in many of the JVs done by the MNCs, that they froze the particular folio. that instruction has to go from the company while getting the ISIN number or while getting the shares dematerialized. So that is the first thing, that they need to make application at the time of obtaining the ISIN itself or at the time of getting the share dematerialized, that this share should be restricted or frozen. At the time of unfreezing, you have to again give out the instruction. Here I see one problem will come, that is you are paying charge again and again. So what happens is that the moment you give the frozen instruction, NSDL will charge a nominal fee. Then again, you are giving instruction for unfreezing. Then there is a subsequent charge. So that charge process is becoming onerous. Here in the private company, I think what to my mind, I was like NSDL and CDSL guy, they charge 15,000 a month. So that becomes a challenge in kind of a custodian fees, as well as giving the instruction in a company. Say, for example, you are transferring 3-4 times. That's again, that is a monetary. And considering if, say, for example, private companies are wholly owned are exempted, then I think that problem will also be sorted out, because then again, it will be only to the big size or big ticket size of private company. But that's a big challenge. But the answer is that yes, it is possible. NSDL CDSL has in place a mechanism. There is no question, there is no doubt about the transparency clause. Next comes certain times, like a lot of times I've come across one genuine questions. What about the articles? Because in private companies, our articles does contain the provision. So many of the private companies article, you'll find the shares be issued in a physical mode, or they mention that shares will be issued and share certificate will be issued. So they have a question that, okay, does it contravenes or does it like in overriding the articles? If I say, for example, if I do not amend the articles, as far as I'm going for the process. See, there is no such like articles is basically for your constitution. So the moment, as far as the constitutional clause we consider, it's a constitution charter. If these are okay, then article itself has to be read well in amendments to the act or the provisions. So there is no as such that it restricts you or it contravenes if you are adopting the or you are adhering to the requirement of the rules. But yes, at the same time, going forward, whenever you get a chance, whenever, say, for example, it's a well advisable when we consider private placement, rights issue, where we are going to the shareholders in such cases, it is advisable to amend your articles as well. Because the best way is that shares be issued in such mode as prescribed by the ministry. Because it should not create a hiccup, because what happens, let you say, for example, you don't amend your articles in a private company. So when you share with the other parties, they do believe that, okay, shares are in physical mode. Though, whereas you will be considering the issuance in a dematerialization mode. If, say, for example, that copy is submitted to the ministry, unnecessary, you will invite one or two later from the ministry. Because by reading your article, by reading your memorandum, they will say that, okay, your company is still not in compliance with the dematerialization of shares. So to avoid those litigation or those unnecessary, you can say, inquiry letters or so-called notices from the ministry, it is better advisable that you should take abundant precautions. As of now only, going forward, that you just take a blanket one that, okay, it should be issued in such other mode as may be prescribed by the ministry from time to time. That covers or that gives you enough protection, or you can say safe harbor provision for the private companies. Because the one case which I was telling you, that one company which has faced investigation in total about 89 and 90, section 89, 90, we all know beneficial interest or SBO, that who is the owner. There only they have gone into the case just because of the minutes. They have got the minutes of the company, which were not serially numbered, page numbered. Again, you know that in private companies also, there are a lot of compliances to be complied with. The 118 section gets applicable to all the companies, even private companies. So the minutes should be properly serial numbered and the resolution should be numbered. So these were not there. The ministry MCA has asked for the copy of minutes and the compliance as well. They said that we have observed there are certain non-compliances. The company, unfortunately, I don't know the reason why they were in so hurry to provide to the ministry the copy of minutes. They immediately have produced the minutes, which were well serially numbered, well provided with a resolution number. And that gave a catch to the ministry that there is something going on in the company, because they were having the old set, and now they are saying this is the actual set of minutes. And they have entered into the investigation and they found out a lot of cases like which I am telling you, 89, 90. So from that perspective, nowadays we are advising even the articles, you get a time when you are approaching the shareholders, it should be your first point of action that get it amended as well. Because that you will provide to the ministry, and the ministry will come across such situation and will raise a objection or will raise a late query on you that why not you have adopted the physical mode. So that's another point of like you can say from the perspective of compliance to be considered. The next, I think that after having said all this, that these are small compliances required to be done. The one more question can person can have, like say for example, in many cases they are saying ki our directors and shareholders are pretty common, because there is a one more requirement of this rules, that rule 9B has come for the private company, that the entire holding of directors, KMP and promoter shall be dematerialized. Means there is no question of those shares remaining in physical mode. So now people were having a genuine question, sir. I've come across a lot of questions during the seminar that say, for example, we don't issue the shares at all. Our company is like in a nutshell position, not considering of raising the fund as of now, at least in next year, 1 year also, or 1 or 2 year also. Why we should get the dematerialized? Because the rule, in fact, itself says that prior to issue of shares, so as long as you don't issue, you have that, you can say, protection to keep it in a physical form. But then to my mind, I will say that well, the law, you can't read it so sacrosanct. At times you read in a spirit also. The spirit is that, okay, prior to going issue, they want, it's a mandate that it should be dematerialized. But that nowhere saying that you don't need to dematerialize at all. Facilitating word itself, which is in there in the sub rule 1, that company shall facilitate dematerialization. That means the first responsibilities of the shares which are held by the directors, KMP and the promoter shall be in demat form.
Or the fresh issue, if you go for the fresh issue.
Prior to that, before the fresh issue.
Yeah.
But then that is what I'm saying, that people are taking a view, sir, that they are thinking that, okay, we will not issue any shares. So let it be a physical model.
Small company.
Sorry?
Will it apply to small companies?
No, this is again exempted for small companies.
That is exempted.
So people are taking a view that, okay, say for example, if you do not issue share at all, why we should dematerialize? So keep it in dematerialized mode, because the reason is that they are not saying that this is the condition. This is rather a forceful mandate that prior to that you should get it dematerialized, otherwise you can't issue. So that is again a mandate, but we recommend that dematerialization should be upfront before, rather when you are applying for the ISIN as well, because the directors, KMP, promoters first need to be well in compliant. Otherwise, it doesn't make sense. The next is come that whatever the, that issues relating to, because when this rule has 9B has come out, the one they have left is that in the sub rule 5, that rule 4 to 10 of the private public company, that is rule 9A, shall apply mutatis mutandis. There are so many things which I have already discussed, like depository payment that they need to do. And then they have to make sure that all the default which is in a payment should be made well and good before further issuing. The one issue is that they are saying that as far as the issue relating to those shares will be considered, will go to the IEPF, Investor Education Protection Fund. So here also people were having so much of apprehension that, okay, IPF, what does it mean? That is there a chance of, is there any chance of freezing those shares or taking the kitty of shares in the IPF bucket? So answer is clear cut, no, because for those shares which are required to be transferred to the IPF are well envisaged under the rules only. Here the IPF only will intervene only for the matter which pertains to the dematerialization of shares and the dispute with the depository. So say, for example, there are certain hiccups, or they say, for example, transfer mismatch has occurred with the depository. Then only they will intervene and will look into and will take the action. But then here only the point of concern is that they will take action. Not that there is a chance of taking those shares in the IPF. Not there, neither they will be considering taking your shares, nor they will be going to impose any penalty as far as the company's internal management is concerned. It's only with the dispute relating to the depository as well as the company. So these are like, well, you can say the few of the things which I wanted to highlight as far as the rule 9A, which were exclusively for the public company, extending it by way of a rule 9B to the private companies as well. Though we have a timeline, because this rule again, has come in the October. We have a timeline till the you can
September.
say September 2024, 18 months, and 18 months will be always be trigger. Say, for example, going forward also, if any company, because the way it is written, the sub rule 2, that you have to check the small company as on the end of financial year. So if I 2024, say for example, some of the small companies cease to be a small company by way of a crossing threshold, then again 18 months they will have to comply with, which is well good, you can say a sufficient times to comply with. And with this also, I would like to take opportunity to highlight on like certain one more changes which we have got by way of like you can say amendment to the MCA rules. The responsibility to designate a person, because you know that at times this is also another, you can say, step taken by the ministry to ensure a timely flow of information as far as your beneficial interest is concerned. So they require to designate a person. It extends to all the company, irrespective of whatsoever your size. Here, there is no blanket, there is no exemption. It is for every company to designate a person. And the reason also, I think it's again, well, genuine reason. Because we have seen the ministry has issued a number of notices as far as SBO is concerned. Many people have got a notice just to make sure that the ministry wanted to know that actually who is the owner. So what ministry has faced, that there is no free flow of information. When you are getting the so-called notices from the ministry is not getting the answer on time. Ministry is not getting a like clue that who is the responsible person in the company. So what they have done by way of a rule, another rule, which is again a 9-1. So lucky number was 9 for the, you can say towards the end of 2023. They have mandated to designate a person, that this person will be responsible for flowing the information as far as beneficial interest is concerned. This rule has a repercussion as well, because this rule says very clearly that if you do not designate, there is a deeming provision. And deeming provision is that if CS is there, he will become by default. If KMP is there, he will become by default. And if both are not there, because in nutshell, if you talk about the private companies, you'll find the applicability of KMPs and CS not there. All the directors, every directors becomes. So the next time you will notice that beneficial interest, if the ministry will issue the notice, ministry will have to make an inquiry. It will go to the every director, and you can't take a view that, okay, I was not aware of those information, because this is a deeming provision. They are saying they are mandating that either designate a person or we'll make every director responsible. And the another thing that we will come to know when we will be filing the 23-24 annual return, because they say very clearly that the details of designate person you have to provide in the annual return. So as of now, 2023-24 annual return, practically nobody has filed. So once we come across that form, which will be modified by the ministry, we don't know how many numbers they will provide for the designate person. Because in case of a deemed, all the directors, so say for example, private 2 directors are there, all 2 directors will become responsible. So whether they will take on auto populate the name, or they will ask the company to provide such a name. But the moment, again, by way of mandating this rule, they are making sure that you are admitting to the information, well, the company is fully seized off, that they need to designate. And these are the person responsible for providing such information to the ministry from time to time, whenever there will be query with respect to the beneficial interest. Again, there was a lot of question, like people were mixing up that whether it's for SBO as well. So I will say rather it covers everything, because SBO means significant beneficial interest. So SBO goes into more wider rule. Beneficial interest is rather much more lesser than what exactly we look for SBO. So by way of a beneficial interest, mandating a designate person, they are trying to cover in all the companies that there should be a one nodal contact point to identify such beneficial ownership. And this has become very crucial, as I highlighted one case also in the just when I started, that there is a holding company and they filed the pattern, shareholding pattern. Immediately the shareholding pattern file, ministry realized that there is no MGT45. So we need to make sure that nowadays going forward, it is the, you can say, the regime of compliance. It is making our compliance framework more robust. Yes, of course, at times we come across challenges, do practical hiccups do come in, like as I mentioned. But then I always in my seminar keep saying that when we start wearing a new shoes, it pinches a lot. but that doesn't mean it will throughout the same day. So we have to get it with that. And gradually ministry also try their best, because we all are here, and since it is a privilege to speak in the chamber, so there are a lot of ways to make a representation. Ministry do consider the practical hiccups. They try to streamline. In fact, in our regulatory framework, we have seen the ministry has all the way the Companies Act 2013, which has completed its 9 year of journey coming from 2014. But after even the 9 years, the ministry has considered 3 times the decriminalization of offenses based on the representation. And similarly, regulatory body, the SEBI, which is again for the listed only, but they are also now streamlining those papers or those regulation, which are more, you can say, onerous one on the listed companies. So they are also paying attention, but we have to brought into their attention at the right point of time and through the right forum. So these are the things that I wanted to highlight, and now I leave the forum to open like for any discussion on the 9A, 9B. And with my once again thanks to the Bharat Chamber, especially Khaitan sir, for giving this invitation.
Mr. Verma, since I have to go for a medical treatment at 5:15, I have 2-3 issues.
Yeah, please,
which
sir.
I thought. Now, my personal feeling is that the wholly owned subsidiary issue has not been deleted because there was no cap as far as the public limited companies were concerned. I mean, cap on the capital, or on the turnover.
Right, sir.
But in this case, there has been a cap on that. So is it one of the reasons that because there is a cap on it, that the wholly owned subsidiary has not been deleted? Because that's the point which they may raise to me, because I thought on this issue. But the whole issue is that there is no consolidation of account. Is there any consolidation of account? There is no consolidation of account. So therefore, if there is no consolidation of account, you may be a small company as far as this particular thing is concerned. But as far as the wholly owned subsidiary is concerned, they want to know that you may have a capital of 10 crore or you may have a capital of 1 crore, but you are managing a company whose turnover is over 100 crores.
Understood your concern.
You see, so therefore, that is the reason probably I feel that may be a reason, because there was no cap as far as the public limited company was concerned. So therefore, this exempted the wholly owned subsidiary. But since there is a cap, they are not exempting the private. I mean, this was my feeling. I may be totally wrong.
No.
Because this is the answer I may get. So I'll have to, contradict that answer that probably you are not correct.
I agree with that. There is maybe a one thought of this, but then again, you will see, sir, the cap has been removed on both the side, though they have kept it for the small companies, just to make sure the identification of the small company. The issue will come, say, for example, unlisted public company, they are saying, even if private companies there, which is, say, for example, a subsidiary of a public company is considered as a deemed public company for the purpose of this act. That is very clear under the rule. Now, what happens is that now that company was enjoying the privilege so far, being exempted under the 9A. Now, with this 9B, which says that every private company shall comply with, there will be contradiction.
No, the other issue is the wholly owned subsidiary may not be a small company. You see, the wholly owned subsidiary may have a turnover of 100 crores.
Maybe.
Now, so therefore,
correct, I agree.
I mean,
but there will be another chances as well.
I mean, you see, it's very. I may be a small company, but through a subsidiary, I have a company which has a turnover of 100 crores. How can they say that particular company can stand exempted because it is a wholly owned subsidiary of mine? So this will be the answer, which will be what we are saying to make a representation. So I thought if I make that representation, the answer will be this, that, if I exempt a wholly owned subsidiary, that means the company which your subsidiary, which a turnover of 100 crores or with a capital of so and so get exempted, that is one issue. I thought you may correct me, because before I make a representation, I thought that feeling came to me. That issue was also in my mind, but I thought I'll.
No, agree, sir, agree.
The other issue is because I see what happens. You see, it's very easy to make a representation, but
obviously without the ground.
But you have to very difficult to defend ourselves.
Yes, sir. Absolutely agree. And most of the times, the representation gets defeated.
The second issue, which was with a lot of our members had a concern, was that you have the shareholders, because you want, but then shareholders are missing. The shareholders are there in your register, but the shareholders are missing, which can also happen in public company and which can also in private companies. And some of the companies are historically very old companies. The shareholders have died. They have not applied. You don't know their children. Their children did not know about the holding. And you really, some person is there, but he's dead. He's not traceable. Now, what happens in that? If that dematerialization do not take place, then what happens in relation to that? That was one question which our members were very concerned that in relation to that, what happens. And another point before I leave, you had a point. You had a point you want to discuss. Yes.
That was not directly with dematerialization.
That was income tax. Okay, sir. Yes.
That Mr. X was my shareholder about 20 years back.
Ah.
So as per the requirements, I informed X that look here, you are the shareholder and we are going with this process. The shareholder X says that I already sold the shares to Y and no physical share is with me. So I am nobody. Now I am no longer your shareholder, but in my report shareholder, I am the shareholder, X is the shareholder. And I am not in a position to trace out Y. What is my responsibility as a company?
So it also comes to dematerialization part. So it also
X said no, I am not.
the same thing.
So that means you're saying out of the way, the transfer deed has been executed. Means the company has no knowledge about the transfer.
नहीं जैसा होता है ना सर अपने ट्रांसफर कर दिया अपने ट्रांसफर कर दिया वो अपने पास यू सी
वो अपने से दूसरे को ट्रांसफर कर दिया
अपने को दूसरे को
हाँ वो दूसरे को ट्रांसफर कर दिया
हाँ, हाँ।
कंपनी ने रजिस्टर ही नहीं किया कंपनी ने उसके पास उसने
है
कंपनी
ही
के पास लॉज ही नहीं किया
लॉज ही नहीं
दैट इज व्हाई आई एम सेइंग द कंपनी इज नॉट अवेयर ऑफ दैट ट्रांसफर
Absolutely, that is what
and
I'm
the
Does not recognize us by.
that is what I'm saying the company will never recognize the company will not recognize also because the moment transfer is there it is the duty of the transferee as well as the transferor. And that is what I'm saying. Transferor will be on the safe side, but the transferee, do not bring it to the notice of the company. It will never be recognized. The company gets straight away reject. All the company at a valid ground. There are so many cases. In such cases, the company can always reject.
एक second. What our learned speaker said that the duty of the company is to only inform the shareholder.
Yes.
There is no obligation or liability on the company. So therefore, that is answered. I mean, you have no obligation. You have informed the shareholder, whoever is on your record. Next experiment.
Those shares may not be dematerated.
Absolutely.
My point was different.
So I'll have to take your leave, sir.
Sir,
Because I have
sir.
a treatment to take at 5:30. Sorry, I have to go for a treatment at 5:30. Thank you very much.
So one more thing, like I was saying that, like to your question, I think I
was discussing with him from an income tax angle, not as from.
okay.
I'm totally aware of what would be.
From the company's perspective, the company has all the right to reject, and company can say that since it has not come to our record for transfer, the company will not recognize that company. Yes, they cannot. And second thing that I was saying that the one major issue, which is going to be another challenge here, that what happens is that in a public company also, though we made a request to the ministry also to consider, but then somehow I think it was not that you can say fructified. But this time we expect that for the private company, they will consider one of the, like you can say, a major lacuna. They say that, okay, you consider whenever you are considering the further issue of shares, you have to make sure your directors, KMP and promoter shares are dematerialized. Now, one practical example I'm giving you, what happens is that in most of the cases, you'll find promoters are not in a discussion term. Or maybe say, for example, directors are not on a same line. Now they are saying, you are sending me the dematerialization request. Okay. I will not dematerialize. He is adamant. He is saying, okay, I'll not dematerialize at all. Because he has also got an idea. Back of the mind, both sides will have the advisors. So he has got an advice of the other side that, okay, I will not transfer, I will not dematerialize at all. Somebody has advised, a good renowned one, that, okay, you don't get your shares dematerialized, let the company think of it doing. Now the company will become this situation will be the company will not be in a position, either the company, if they consider to go ahead with the issue of shares, that will be considered as a contravention of the provision because the shares are not dematerialized despite knowing the fact the company is going. Second, even if the company says, okay, see, I have reminded my shareholders and directors and they have not taken a stand, whether this will stay valid or not is again a questionable, because in a public company also so far we have not come across such case, but in private it is going to be a major challenge.
upfront dematerialization is, that's why.
That is why I was saying this point that self-facilitate and dematerialize prior to. So my recommendation is that the private company owners should never be like should never sit on the chair and wait for those 18 months to complete, or maybe a time when I will consider the issuance of shares, I will dematerialize. Rather, a good practice is that the moment you get the ISIN, make sure that everyone's shares are dematerialized, because at least that will not block the survivability of the company in the future. Because when the directors are in a deadlock situation, promoters are in deadlock situation, what will happen? The company will say, I need the fund. Directors will say, no, we will not dematerialize the shares. So now how can you go for the funding? How can you have the private placement? How can you have extension of your capital? You cannot do it anyway.
Actually, if
right.
you further deep dive this topic, it will lead to another serious issue, which is corporate governance. That means corporate governance and family governance in small family businesses and small companies privately held will also become very important, because when you say large companies में ऐसा problem नहीं होता है, the reason is because of presence of public shareholders, because of presence of corporate governance, because there are independent directors to sort out matters, to facilitate sorting out matters between differing promoter directors. Okay, so that will bring it to another level actually, where corporate governance in small companies also becomes very important, which actually there should be, but nobody has actually looked at corporate governance in private companies.
Absolutely agree, sir. And no doubt, you mentioned it rightly because you are on the board of the very company. So you know very well that, like in some cases, like as you know, that the family governance or family intervention will come in for sure. Because we all have known, we all know, and it is a right, not right the forum to quote the name of the startups also. We all know that the big concern of the ministry was also with itself, the governance of startups. The reason being only that many times we don't go into nitty gritty. What we think, okay, these are the compliances, okay, compliances karna hai. So my concern is also that no longer it's a compliance requirement. Don't think as a compliance as a burden. Now I'll say compliance is a necessity. It has become a necessity tool to make the company run smoothly, free from all the encumbrances, free from all the hiccups that what you can face from the ministry. Because, you know, at times we look at the things and we say, okay, abhi nahi hua, theek hai, koi baat nahi. 6 months later on, we will comply with it and we'll do it. So, you know, 6 months later on, you will comply with it. It's okay. But then your certification, which will be issued for the entire financial year, will highlight the same. And you never know when the ministry will catch the hold of it and they will sit on this inquiry that, okay, you have not done on time, why there was a contravention. So in order to avoid all these issues, it is always, like you can say, advisable to initiate all those steps, especially in a family driven, or you can say where small companies we always have with the close heads, or you can say the brothers, sister family. So there,
Right.
at least more, you can say precautions or more abundant approach is required as far as this dematerialization things is concerned.
Thanks. Swarnaji, you were having a question.
Yeah, please.
If you can give him a mic, please.
Has to be a tri-party agreement between the shareholders, company and the transfer agent for the purpose of opening of the account. This is what the rule says. Now, if none of my shareholders are coming forward, we will not go for dematerialization. How then that agreement can be entered into with the agent?
Hey, you see, here I will say, you mean to say tripartite agreement for the purpose of dematerialization with the depositories, right?
Yes, yes.
See, here I will say it's a tripartite agreement is between the company,
Company
depository, and the
and shareholders.
company's registrar. That means company itself can act as a registrar. So I don't need to make the shareholders party. I would just add in, sir, your tripartite agreement is understanding is correct. But say, for example, I'm just saying this agreement is basically between the company with whom the depository the company will enter into it, and the third win registrar. That means one who is the custodian of the shares. That means the company itself. Because in a private company, we can't think of appointing the RTA at all. Because the kind of a fees, again, already I mentioned the NSDL and CDSL fee, which I should not quote, but then they are charging so much. And then if you appoint the RTA, then I think more than audit fees will go there only in the compliances. So that is not the intent. They want only the company to act as a registrar, and company will sign in that capacity also. So company will sign in twin capacity,
Twin capacity.
and then the another one will be with the depository.
So,
Sir.
your shareholders who are not agreeing for dividend, what is not to them? What is their responsibility?
That is what I was, sir, discussing. This is that, say, for example, if I keep requesting the shareholders and if they do not dematerialize, my concern is that I cannot go for further issues of shares to them. Because if in future, say, for example, they are not required, dematerialization as of now is required for three category: directors, KMP, promoters. But then later on, if I issuing a fresh issue of shares, then whosoever is a subscriber in the private placement, any shareholder, has to make sure that it is in demat mode. So going forward, my concern is very, like you can say, almost it will be addressed. Because if the shareholders is not willing to put the money, he will not get applied. And I will not consider the person as a allottee. If I have to consider the person as a allottee, then I will make sure that the person gets the dematerialization of account for sure. So,
Sorry.
so as far as he is going to subscriber, he has to make sure demat. Now, say, for example, he says, okay, I will not dematerialize at all. You don't dematerialize, then whatsoever further issue of shares I will consider, I have to make sure, say, for example, private placement. So if in a private company, I can do it to the members only. So if, say, for example, out of 4 members, he is not willing to, so I cannot issue at all. I will always do to the 3 members and he will be left out of it. Yeah.
So no wonder there is a now this era is of LLPs. All small businesses are registering as LLPs. Not only this demon is likely to affect, the other demon of double taxation or dividend will also be taken care of.
People will be opting
Yeah,
for
But
now-
at the same time,
so,
LLP
yeah,
is also
convert into LLP.
So yeah, small businesses going through LLPs is becoming popular. So I have, we all know dematerialization has actually revolutionized the way in the capital markets also overall, and in many other ways it's become very, very convenient. But along with this, there's a nuisance also coming up. Okay, so we experienced recently that a company had the company secretary had resigned, and there is a limited window given for replacement of a company secretary. Now, company secretary's replacement is not कि किसी ठप्पा company secretary को लगा दिया वहां पे. It's an HR issue.
Yeah.
A right kind of a person with the right hard skills and soft skills has to be hired, who may not be available in that small window that is given. I think it's 90 days or something.
3 months.
3 months. Okay. And if it is not
Listed.
listed. Okay. So that didn't happen. So then after passage of 90 months, the regulators would call up and say, would send notice and say that you are in non-compliance. So you have to comply. Otherwise, you will have to pay this fine and then also comply. Otherwise, आपके जितने डायरेक्टर्स हैं सारे के सारे डीमेट अकाउंट्स फ्रीज कर दिए जाएंगे. Okay. Now imagine what all is there in the demat accounts. One, today everything, all the securities that you've invested in, be it equity, debt securities, even your gold bonds, and so many other things. Everything is demat. One clerk over there, because the fine was 17,000 rupees. This company secretary, the person who was assistant company secretary or something like that, whatever in that company, to save 17,000 rupees for the company, he was trying to negotiate with them कि भाई इसको छोड़िए हम वो कर रहे हैं. And on the D-Day, the department actually froze the demat accounts of all the directors, including independent directors. Some of the independent directors were having shares worth not 17,000, 17 crores. One of them 1,700 crores for 17,000 rupees.
One of the rarest case.
Okay, now imagine. So what is the kind of power? So what is your opinion of this nuisance value and what you all in the profession are actually, how you are addressing this?
Very well, sir. Since you are in a capital market, So everyone knows you very well. And then you have pointed out on the, you can say, hard point only that, yes, obviously, we all know that SEBI regulation, we are talking about the LODR. He referred to the LODR listing obligation. And I think the name is very absolutely right because it's obligation kind of a thing. Because the name itself says listing obligation. So, well, the moment I look at the name, I say it's a comfort. More than that, the painful is the regulation 30. Those who are working in the listed company, they know that regulation 30, how we work it out, that whether it's a material event or not for the company to disclose. And ultimately, if you look at the scenario, why they are considering of revisiting regulation 30 is that their essence was to make sure investors are informed of a particular major events. Now, what is happening? The companies are uploading 50 rupees penalty, 100 rupees penalty detail. So ultimately, they are losing the, you can say, the real essence of regulation 30. Similarly, they have brought in a provision where they are saying replacement of whole-time directors, KMP and CS, including CS, CFO, they are saying the timeline is within 3 months you have to appoint. So I think they have considered the notice period of the other company that, okay, whenever the person joins in and when the person is getting out, they have given a 3 months window. But here I will say that, yes, obviously timeline is short. That is also they are revisiting because when it came in, we were discussing that, okay, 3 months from the perspective of one, whoever will come will take 3 months is okay. But in a big company, handover process itself takes a longer time. And then the person who is coming from a big organization will also take a time. He will not join in 1 or 2 months or 3 months. He may take 4, 4, 5, 5, 6 months. So there will be some issues. And as you rightly pointed out, identifying a real position, or you can say a candidate who can fill in really the position of that company secretary requirement or CFO requirement, etc. It takes time because you can't go door to door and hire anyone. So it requires time. But as far as the SOP is concerned, well, I will say they have given, because that was our discussion also, had a lengthy discussion with that, and I got a privilege to be a part of this series of governance papers also. So there they are saying that, okay, frozen concept, whatever we are freezing the shares or whatever we are imposing the penalty. See, we are giving two reminders to pay us the fees. But you are ignoring us. That's why we are running to third step of freezing your shares. And the penalty also, it was like during the COVID time, they were supposed to implement and they implemented it because everyone was thinking that, okay, they will not implement it because January 2020 was the deadline. People were so relaxed ki ab to COVID aa gaya. So they will not impose it, but they imposed it. And they said it very categorically that, okay, see, our SOPs as far as considered is a penalty and we are giving you the protection that, okay, after imposing the penalty, you come with a valid ground, make a request for waiver of the on what ground we can waive your penalty or what ground we can refund your amount. So in many cases, they have refunded as well. But again, this is, you can say, a nuisance kind of a more than that, like, because again, refunding requests are not that 100% processed because in only 5 or 6 cases out of 100, they genuinely consider the concerns of the company. Otherwise, they continue with their whatever penalty they have decided. They hardly consider the cases of company. But again, SOP and this penalty, I was saying that, sir, we tried a lot to present our issues, present the representation on behalf of the ICSI. ICAI was also part of it. But then they are not listening to this because the reason only being they are saying that your freezing of shares, your shifting the shares to Z category. In fact, they have a provision that the company will be shifted to the another category shares where the trading will be not allowed in a period of, because you are from the market, so you know that they will block it for 15 minutes. They will not be allowing it trading and all. So they are saying these all we will do after giving due reminders to your company. There will be 1, 2 reminders will go, and then only we'll take this harsh step. And again, this is harsh step is protected by your subsequent representation for seeking the refund. So we are not saying that, okay, say for example, I have taken a penalty of 50,000. I'm not saying, okay, 50,000 I will not give you. We'll give you. Make a due representation, make a strong representation ground that how you have failed there. So it's a kind of a mixed reaction, but the timeline again, the 3 months is very narrow. That they should consider because similar is the case in case of independent directors as well. You know that many times we all know independent directors, all the big companies want a big stalwart on their board. So at times it does take time, like independent director has resigned for some reason or some personal reason for prior commitment. So 3 months timeline, again, you call a meeting, again, you have a NRC because there are a lot of meetings requirement also. NRC first will be there to evaluate the parameter. Then again, they will recommend to the board. Then again, it will come to the NRC final candidature, again board.
No, no, and the point is here is also the fact that how are independent directors responsible for the act of one clerk in the company and one clerk in the regulator's office? How is the independent directors responsible? So this, what I'm trying to say is this: too much of power has gone into the hands of very junior people in the regulator's office by through this dematerialization thing. And एक महीना से ज्यादा लगता है अगर आपका एक बार डीमेट अकाउंट फ्रीज हो गया ना, उसको रिलीज कराना more than a month. And for some people, you know, when investors are investment is a full-time job for them. And so this is
Nahin, I was coming to
So,
that point.
yeah.
That is a very valid point. Ki once they demand,
Yeah,
freeze the demat shares, that's very easy because they will take a few hours or a few minutes only
Yeah.
to block your demat account.
Yeah.
But immediately after blocking, also we have seen many cases where the company has already paid the fees.
yeah.
They in a hurry, they have
It-
paid it through NEFT and then the transaction share the UTI number. But then the stock exchanges now will take time to unblock the shares. That is again a cumbersome process, a lengthy process.
Talking of stock exchange, Calcutta Stock Exchange is becoming another very, very, you know, big nuisance case. And because of that, there is a lot of directors who are whose accounts have been frozen because of non-compliance at a defunct exchange, actually. Anyways, that's a different topic. One last
yeah,
question in the interest, yeah.
Anything can you share about women director? The company is not having women director as required.
See, again, women director, the law has a, you say that law has given you the enough time. In fact, the 6th month is a time period within the commencement of the act. And you recently, we have come across a case. It's an adjudication order. They have interpreted in a way. They are saying that, okay, when we read the independent women director, the other directors, the independent directors, where the vacancy fulfillment is 3 months. So they are saying if the women director, you are not fulfilling up the position within 3 months from the date which it hits the trigger, it will be a contravention of the provision. And there is a penalty which may go to the extent of 2 lakhs on the company and the 50,000 to the officers in default. And officer in default, again, I always say section 260, subsection 60, officer in default is like they have made it a blanket definition covering everyone from CS, KMP to the everyone, immediate authority, as well as they are saying where the immediate authority is not identified, all the directors. And even all the directors, you are saying that directors are just like on the seat and they are not doing anything. Then they are saying whosoever is controlling or under whose direction the board is accustomed to act. Say, for example, a promoter is there. Many cases, hum log karte na, promoter is there, but then they do appoint the directors there. So they are saying in that case, even the promoters will be OID, officer in default, and he can be penalized if there is no women director. And especially, you know, that with due respect, like we all know that, yes, we are, in fact, India has seen a down that line, robust change, you can say, in terms of women empowerment and women coming to the board of directors. But we have seen recently there were a number of like studies has come out where they are running shortfall of women candidate. And what happened, unfortunately, in listed company, if I shifted to the listed company, the essence was to have women independent. There, indirectly or directly, they are finding the household, or you can say common friends, wife, spouse, who are coming on the board as independent director. Because the reason being, at times we understood that the law has been framed without doing a rational analysis of availability. Because you know that economics, we all know demand supplies the need. So they should have considered. And similar situations are arising in terms of independent directors as well. So nowadays,
That's a
even the
different
ID
topic.
requirement.
We can keep it for some
Yeah.
other day. I think in the interest of time, we need to wrap
Yes,
up
sir.
this session unless somebody has any important last question. Okay. Mr. Ravi Verma, members of the chamber, guests and friends, at the end of this important awareness session, it is indeed a pleasure to propose a hearty vote of thanks to our guest speaker, C.S. Ravi Verma, corporate law expert, for addressing us today. Dematerialization for private companies signifies a pivotal shift in the Indian financial landscape, aligning with global trends towards enhanced efficiency and transparency. I owe my sincerest thanks to CS Verma for sharing his expert opinions and advice on dematerialization of securities in digital era in a very lucid manner. Thank you for addressing all the questions regarding issues related to DMAT raised by some of our members. I am certain that today's session has enabled our members to gain better understanding on the subject. I would especially thank our own Shri D.N. Agarwalji, Chairman of Company Affairs Subcommittee of the Chamber, for his special initiative in organizing this important session. With these words, I now request all of you to join me in carrying a hearty vote of thanks to CS Verma with appreciative acclamation. And there's a small memento for you.
Thank you very much. Thank you once again. Thank you so much. Thank you. Thank you.